So living annuities are one of the most widely used retirement products in South Africa, but there's still a lot of confusion around them. And I think they seem so simple at the surface, right? It's easy. It's like a few moving parts, and this is an easy thing. But I think there's still a lot of confusion in terms of what they allow and what they don't. So can you change your income drawdown sort of midway through the year? Can you only do it once a year? Why is that? Can they be claimed against in a divorce? That's a big one. What about nominating multiple generations of beneficiaries? Is that even possible? So there's lots of questions that we as financial advisors face every day, and it's not always, I guess, or the answers really aren't always what we expect them to be. So today we're going to unpack the fine print and explore our theme for the year, the real rules of living annuities. Welcome to PROpulsion, the weekly show for financial planners and advisors who want to build better, more successful businesses. I'm your host, Francois du Toit, and every week we dive into the practical strategies that matter, from growing your client base and improving your services to developing yourself and your team. Whether you're running your own practice or you're part of a larger firm, you are guaranteed to find actionable insights to help your business thrive. So with that, welcome, and let's get into today's episode. So today I'm joined by Lize de la Harpe. She's the Senior Legal Advisor at Sanlam Corporate. Lize is an admitted attorney with nearly 20 years of experience in financial services. She chairs and serves on several retirement fund boards, contributes actively to industry committees, and lectures on pension fund law, divorce claims, and Section 37C death benefits. She's passionate about the retirement fund industry. You can see it through everything that she does and what she writes about. And she's also well known for making complex legal issues easier to understand. So on that note, Lize, warm welcome to the show.
Hi, morning, Francois.
Thank you very much for joining me today. And I must just give a shout out to Jaco van Skalkwyk, who managed to introduce me to you as well to get hold of you. So thank you very much to Jaco as well. Let's dive right in, Lize. Hopefully I got the introduction 100% right, but I want to get straight into it. There's quite a few things that I want to get into it. And the first place I want to start is with drawdown rules. How does it actually work on a living annuity?
Okay, so in its simplest way to explain it is living annuity is something that's actually specifically defined in the Income Tax Act. And if you go and have a look at its definition, it's probably one of the few definitions that I actually keep on hand, because the definitions of that actually tells you exactly how the product works, when you can do and what. And part of that definition is that the income that you get the annuity income is specifically done in accordance with the formula that's then prescribed. So it's gazetted. And in terms of government notice 290, that's the current one. It says that once a year on the anniversary of the policy inception date, the annuitant has the option to then select a drawdown between the gazetted percentages. So right now that's between 2.5% as a minimum and 17.5% if it was an annuity policy entered into after 2007.
So, I mean, then obviously the big question, I think something that we never thought about really is like, one, why is it limited to a percentage and why only once a year? Like, is there any specific reasons for that?
Now you asked something before my time. I'm not sure what the reasoning is for why it's only once a year. But remember, at the end of the day, what you need to make sure is that income doesn't get drawn down and depleted before the end of the person's life. Remember, this is supposed to last you for all of your retirement. But no, I can't tell you why they worded the legislation like that. No.
I mean, because it is quite interesting. I think a number of years ago, people could change sort of the incomes mid-year or somewhere. They had options. And then that was stopped and said, well, it's only once a year. And also, like, it's interesting to me, like the way that how the product works is usually around the fact that you have a percentage, but that percentage only really comes into play at the renewal every year. So right at the beginning, and then so usually then that amount is fixed. So it's not like they calculate the percentage every single month that they need to make the payment. Like most of them go like, so there's R1 million in the account, you're taking 5%, so it's 50,000 rand divided by 12, and that's what we pay you monthly. So that's quite an interesting way that the product providers are going about it. But is there a particular reason? Is it just to make sure that you don't draw down? Do you think there's any other reasons that made them stop this mid-year change?
Okay, so let's just take a step back. So there was many years ago, before a living annuity was specifically defined in the Income Tax Act. The way then it worked in terms of, I think, SARS interpretation notes and stuff. I mean, we're talking about many years ago, long before my time. So at that stage, I know from what I've heard that there would be instances, I think it would be like, severe economic, like financial hardships or something, where there was some kind of a discretion that could be applied. But that was before it was so strictly regulated, I almost want to say, before it was actually written into the Income Tax Act, and now it's prescribed how it must be calculated. So now the fact that it's specifically prescribed, and this GN notice that I mentioned says how it must be, when it can be adjusted, insurers don't have a discretion anymore.
Okay. And then also often it would happen, and I know this is maybe sort of a financial planning advisor conversation, right? But do you ever get requests, or I don't know if that's part of your realm, but where clients do throughout somewhere in the middle of the year, they come and say like, I need a little bit more. Is there a way for us to handle that conversation around that? Because we don't have an option, right? It's not like there's a life-changing event and therefore we give you sort of a special treatment. Any advice or any thoughts around how we can guide clients?
So let me put it this way. So I've been in Sanlam now for 13 years, and for the first almost 12 of it, I worked within Glacier, which is the list administration platform where we administered living annuities specifically. So I did see those kinds of instances. Now I focus more on the employee benefit side, so I'm not close to clients, the end client, but I did see that before, and it's actually quite terrible. You do see it, where somebody might have, let's say they retired from a retirement annuity policy, but they are still earning an income from somewhere else as well. Because obviously, a retirement annuity is not employer linked. It's a retail product where, their circumstances change and they desperately need more money. So you do see that come in. I think this, to me, if I were in your shoes, obviously I'm not a financial advisor and I don't deal directly with clients. And I take my hat off to those that do. I think it just gets more and more difficult to do that, and more regulatory cumbersome to do it. Is you need to make sure that the client understands this product when they invest into it. I think that's part of I know right at the outset, you've got your record of advice, all of that, but I think it's incredibly important for people to understand the restrictions applicable to a living annuity, because not everybody understands that. Because then at least what you're getting into as well up front, which will make those conversations throughout less likely to happen.
Yeah, so it's about managing expectations and educating and reminding the client as we go.
Exactly. And also making it very clear what's the difference between it's your provider that's saying no versus the law says you can't. I could get 10 Rand for every time you get it, but provider so-and-so said yes, what's your problem? There's a difference between when you can escalate up to the exco guy from the golf course and get an exception versus there is no exception. It's legislatively restricted.
Yeah. So talking about getting money out of living annuities, are there specific cases where we can commute, and take the cash from a living annuity?
Yes. Okay, so excuse me. Before I answer you, I just want to take another step back. Now, remember, what is this product? In terms of law, let's just ignore all the, annuitization, provident fund, T-day exceptions. Let's just speak broadly. When you retire from a fund, broadly speaking, typically you can only take a third in cash, and the remaining 2/3 you have to buy an annuity with. This is a compulsory post-retirement product. And the whole point of that is that the state doesn't want to end up having you as its burden, and they have to take care of you because you didn't make provision for it, right? So in that sense, we have to look at it from the outset as the whole idea of a living annuity is to provide for you an income after you've retired. So in that sense, it's not supposed to be easy to access this money. So there are only 2 instances in which you can commute a living annuity. And that's also, like I said, that's why I love this definition of living annuity in the Income Tax Act. If you look at the definition, it literally tells you when can you commute it, and that's it. If it's not in that definition, it's not an option. And that's when it falls below a certain gazetted minimum, and that minimum is low. It's 125,000 rand, and it's been that amount for quite a while now. And there's no speak yet of upping that. And that's the whole point. The point is you're not supposed to be able to cash out these products. So that's the one side. And the only other time that you can commute a living annuity was actually added into the Income Tax Act a few years ago, not too long. Oh, memory serves me, I think about maybe 3 years, but I speak under correction, is where a trust was nominated and took over an annuity at the original annuitant's death. What you would often have is, let's say, for example, God forbid, something happens to me, I have set up a testamentary trust for my children. And I nominate that trust to be the beneficiary on my living annuity. Let's say I'm already retired. Now at my death, and that trust is specifically set up to cater, and let's say until my youngest turns 25, and then the trust must dissolve. So now let's say I pass away, the trust accepts the nomination, the money goes to the income, the trust, it's issued in the name of the trust, it gets taxed according to the trust rates. Obviously then, let's not go into whether this was a good financial decision, but anyway, now let's say my children, my youngest turns 25. So now technically speaking, in terms of the trustee, that trust has fulfilled its purpose. It now has to dissolve. But the problem is you can't dissolve a trust while there's still assets sitting in the trust. So what you would find is you would have a scenario where, let's say there was still 5 million rand sitting in that living annuity. That trust couldn't dissolve while that product was still an asset that belongs to the trust. And you can't commute unless it falls below that minimum, which was 125,000. So they amended specifically the Income Tax Act definition to make provision for a second option to commute. So you can commute in anticipation of the termination of a trust. So in the sense of, in that specific scenario now that I'm an example, there is now option then to commute the ILA as well, so that you can be able to then wind up and dissolve the trust. So that's literally the only two options. So I've had people come and ask, okay, but what about immigration? And, so it's, they don't talk about immigration anymore. We're now talking about when you leave South Africa and you're not a resident for tax purposes anymore. So most people know, but you know what, there's exclusions in the sense of, or exceptions maybe, like in the retirement annuity fund space, preservation fund space. Recently now with two-pot, it's in the for other funds as well. But what if I leave South Africa and I'm not a tax resident for uninterrupted period of 3 years? Can't I then cash out my living annuity? The answer is no. And it's very simply, as you can see from the definition, it's not one of the options. There's only two options within which to commute, and that's those two that I just mentioned.
Awesome. Thank you very much. So I guess one of the questions, and I do want to ask it here before we move on to divorce and legal cases, but I don't know, Lize, I mean, you can tell me where you've got any just thoughts maybe around this, or if you've got any insights, I mean, that's great. But if you think about, when somebody's still providing for retirement, right? And I'm 25, 30, 35, 40 years old. I want to be able to invest however I like. And then I get to retirement. And then often the notion is that, oh, now I've got to be a little bit more conservative, blah, 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 blah. And there's these life stages where, you sort of invest aggressive. And as you get closer to retirement, you get more conservative, whatever that may be. But obviously, we have Regulation 28 that says, well, whilst you are providing for retirement, you cannot invest the way that you want. You cannot take the risk that you maybe need to or want to, because we tell you what you can and can't do. And then you get to retirement and you retire and you get your living annuity and you can invest 100% offshore if you wanted to. So obviously, there's no, Reg 28 does not apply to living annuities. Do you have, and I'm just asking, do you have any insights into any reasoning behind that, why that might be the case?
I must say recently there was a bit of a LinkedIn conversation on this as well, so I'm very careful now so that I get phoned afterwards. I think it was Martin Hess as well on LinkedIn who had a conversation going about this. So this does seem to be something that's very top of mind, and I almost want to say controversial in a sense. So yes, you're correct. Regulation 28 is voluntary. If it's post-retirement for a living annuity, it's not compulsory. But remember, it's not completely blanket cowboy country either. the insurer is bound by their CISA standards and things on that relate specifically to annuities as well. So it's not completely, just do whatever you want kind of thing. The reason why I'm not entirely sure what the thinking there was. I understand the argument of the fact is that it is supposed to be, should be as prudently monitored, if I can put it that way, as while you are a member of the fund. But I think we must try and see that right now, for whatever reason, be it as it may, once you retire from your fund and you choose a member-owned living annuity, and the fund then takes that retirement benefit, transfer it to your insurer of choice, your fund membership comes to an end and the fund steps out of the picture. So there goes the Pension Funds Act. Now you're solely within the space of the Insurance Act, long-term insurance legislation, and obviously the Income Tax Act as well. So that's the thing, in the sense that that's why we don't have Reg 28 compulsory on a living annuity. But as to why they did it this way, unfortunately, I'm not sure.
Yeah. I've got a few speculative ideas, but let's not go there today. Otherwise, we both get phoned afterwards. But it is definitely something.
Speculate off the record.
We'll take it offline. So let's talk about divorce and legal cases, because I think that's also a very interesting area, obviously, and there is this notion that obviously, because the living annuity is there, you can see the living annuity. If you think about how retirement funds work at divorce, right, and then how living annuities be split when you get divorced. What is the situation?
So the answer is no. But now we're going to see the chat box explode here. So everyone's going to go, oh, she doesn't know. Why did you bring this school? She doesn't know the latest developments. Yes, I do. So let me tell you why I say no. So I think, unfortunately, the Montanari Supreme Court of Appeal judgment that was handed down in 2020, if memory serves, really confused things. People really got it very confused. And unfortunately, a lot of media publications also didn't report on it technically correctly. And I'm not knocking anyone. It's very technical. So let me just start off with saying, so first and foremost, if you go to a court and you want to get divorced, and you want to claim from someone's pension fund, or let's say retirement fund in general, the court's going to look at how's pension interest defined in the Divorce Act. Then there's a specific section in the Divorce Act that enables the court to then deem that pension interest, that's a defined term, to be something that's a fictional asset, a future asset, to deem it to actually sit in the pot of patrimonial assets that can now be taken into account. And then there's a subsequent section that enables a court then to assign a portion of that pension interest to the non-member spouse. Now, let's just stop there. So pension interest, there's now a new definition added into the Pension Funds Act by the Pension Funds Amendment Act when they updated the Act for two-part, where people also started thinking, okay, but now that solves it. It doesn't, but I want to take you through it slowly. So first and foremost, the whole point is pension interest is tied to what membership is still sitting in a fund. If you've retired and you've purchased the living annuity and your membership to the fund has ended, there's nothing left. There's no link left between you and a fund. The fund holds nothing on your behalf anymore. You don't have pension interest anymore. But more importantly is actually, how does the product work? How the product works, there's no access to the underlying capital of a living annuity because it no longer belongs to the annuitant. It actually sits on the balance sheet of the insurer. All you have, once you enter into a living annuity contract with an insurer, you give them the retirement amount that you had in return, and they issue a policy. In return, you receive a right to annuity income. That's your only right. You do not have a right to the underlying capital anymore. So therefore, you can't make a deduction to give to anybody from the underlying capital. It's no longer the annuitant's assets to deal with. Now, that has always been the case. So at the time, the Montanari case was actually dealt with 3 Glacier-administered living annuities. And I worked for Glacier at the time, so I was incredibly closely involved in that case. For my sins, I very closely ducked having to go up to Joburg to be an expert witness. I luckily got out of that last minute by just providing detailed legal views that could assist in the application papers, etc. So long story short, the media unfortunately summarized that case as, oh, things changed now. Now you can claim from a living annuity. And it didn't say that. If you unpack the detail, because it's a very technical detail of that case, you'll see the court didn't say that. The court agreed with all the previous decisions, saying that the very nature of the product, so never mind the fact of your pension interest definition problems, all of that. So let's ignore the recent pension funds amendment definition as well. The fact is, by the very nature of this product, there is no access to that capital underlying the policy by the annuitant because he's not entitled to it. It's not his asset. He only has a right to the annuity income. And that little bit, previously, that income was viewed by the court. Look, you can at least take that income into account when there's a maintenance claim. So when you're looking at someone's, in terms of how maintenance laws work, when you have to decide, a court has to make an order with regards to maintenance, they will look at the respective means of the parties. And part of that will obviously be what money do you have to pay maintenance with. So it was always taken into account, but that's kind of where the buck stopped. Only thing that Montanari changed, which was completely new, is the court said, wait a minute, though, that shouldn't be the end of it. Because in terms of this annuity contract, you as the annuitant have a right to future income from this policy. And that future income should be seen as an asset sitting in the estate when calculating accrual, because that was specifically a case with regards to they were married out of commutative property with the accrual. And the reason the matter went all the way to the Supreme Court of Appeal is that the then still wife wanted the annuity policies to be taken into account when the court calculates the accrual calculation, which obviously the annuitant didn't want or argued can't be. So that was different. The only sad bit, if I can put it that way, is the Supreme Court of Appeal went right. So that's what we've decided. You can't disregard that income and only look at it for maintenance. That right to future income is an asset. So you should calculate it, and that should be used in the accrual calculation. The only thing is the court went, but look, we don't know how you're going to calculate that thing, though. So refer it back to the trial court, bring in your expert witnesses, and fight this thing out. Because remember, how long is a piece of string? How do you calculate that right to future income when it's dependent on the drawdown rate that the member can revise every year? It's dependent on the market fluctuations, the underlying investment performance of that money. It's not a guaranteed income for an X amount of years that you could easily just calculate. So that, how to actually calculate that, and in the sense of that's what Montanari changed. It said that right to future income, you should calculate, and that's an asset that can then be shared upon divorce. However, also importantly, remember, let's say whatever the calculation is, you bring your, actuarial expert and senior counsel, and you do a calculation, and another court agrees with you on how you did it. That payout will have to be made good by the annuitant. It can't be deducted from the living annuity because, like I said, and as the court confirmed, that underlying capital, you can't touch it. It's not the annuitant's. So either way, that will remain an issue between the divorcing parties. It's never going to be deducted from the annuity itself. So I know that's a mouthful, but I think it's just so important that that lands correctly, because 9 out of 10 times when this case is referred to in a pushback letter, people believe that it completely changed the position, and it didn't.
Yeah, and it is quite a technical thing, right? And my further question would then be, would that also be the case with a life annuity, though? Because they also have a right to future income. So would that even be the same thing, or is this not only because there was a living annuity here, but would this apply to annuities in general if I have that, right? Because with a life annuity, that calculation should be very easy.
Yes,
right?
I agree with
Living
you.
annuities, yeah.
Yeah, I don't think the case has to be read that restrictively as only applying to a certain kind of annuity. And in actual fact, a guaranteed annuity would actually be easier to do that calculation, yes.
And I'll circle back to the estate planning side of it as well. So we'll come back to that with regards to living annuities now specifically. Is there anything in particular that advisors and planners should look out for if they have clients who is going through a divorce or are going to go through it, like they know here's something, or when they come across a client which says, we're now getting up, guess what, we're getting divorced. Is there anything in particular that you want them to keep in mind, from today onwards, if this is the first time they've heard about all of this?
Let me answer you this way. So I'll answer you from you. Your client is the person who is intending to claim from their spouse who is about to retire, already retired, versus the other way around. So let's do the first way around. If you are helping a client, because I think a financial planner plays such a big role in the whole divorce process. Now you might think, no, goodness me, like we don't have enough fit and proper and phase and all of that to deal with. We're definitely not going into the scope of legal advice for divorcing clients. It's incredibly important because this is such a major life event. You are literally overnight having to start over or completely redirect your financial future and your financial, even eventually retirement planning, estate planning, all of that. So I think an advisor can play an extremely important role in that process. And part of that would be then for everybody to understand what is possible and what is not. So having a better insight on what is actually possible, because I've also seen, you see this, where people, I've seen, not going to name names, obviously, I've seen people that will sign a settlement agreement and they're just waiting for a court date. And literally within days of being served with the summons, they go and retire from their fund, thereby locking the capital into a product that they know can't be shared, even though they signed a settlement agreement. These are the kinds of things that I think would be important. First of all, it's most important that you make sure your client is dealing with a divorce attorney that understands pension fund law. I'm not knocking attorneys. I am an admitted attorney, but there's a big difference between being a divorce specialist and being a retirement fund specialist. It's not the same thing. The one doesn't guarantee the other. So it's very important that your clients also got, especially when we're talking about large retirement funds, values, those kinds of things. And it impacts what you might end up coming to terms with on how you decide to settle. In the sense of you might, based on how you do your calculation, forego other maintenance or whatever because you think you're going to get a big pension payout from that person's retirement fund. Meanwhile, they've already retired and you're not. So I think that's something that would be an important discussion to have with your client from that perspective. If it's the other way around, in the sense of you are the client, your client, is already the one that has retired or is about to retire, I think it's also important to explain from what I've just said so that they understand. Don't bind yourself to something under the guise that you are going to be able to not pay anything from your pocket. It'll be just deducted from your annuity. Because if that, if that divorce order has a settlement, for example, that you've entered into, where you agreed to share half of what it is, that order is not going to be enforceable against the insurer because they can't pay out something that you don't have any access to. It's no longer your asset. That doesn't mean that your ex-wife or ex-husband lost their claim. It just means that they can't enforce it against either the fund because you've already retired or against the insurer because of the nature of the product. You might end up being taken back to court to now make good on the settlement that you undertook and was made an order of court to pay out. So I think that's very important to make sure that clients, but it's not your role to guide them through divorce, but I think with having enough understanding of the product, make sure that you can at least assist the client to double check that they've got an attorney that understands exactly what are the restrictions when it comes to retirement and post-retirement products.
Yeah, because also I think clients get a lot of advice around the braaivleis fear, like that's probably also they will come to you with a lot of interesting ideas and plans and strategies. And then, I think it's important. So let's quickly talk about beneficiaries and nominations. This is also an important one. A couple of questions rolled into one just for time's sake. Who can you nominate as a beneficiary? And why don't we allow like sort of third line nominees? So you nominate one, and if that one, then the next one, etc. So who can we nominate? And what is the case if I nominated somebody and that person has passed away and I didn't update my beneficiary nomination. So let's chat about that if we can, please.
That's a very good question. So first of all, let's just take one step back. So in terms of the definition of living annuity, you have the right to nominate someone. Again, doesn't mean you have to. If you don't, it will get paid to your deceased estate at your death. So basically, that's it. And that is also why there's restrictions on what the options are at the point of the insurer, if I can put it that way, once you've passed away. So the living annuity definition makes it clear. There's two ways, the two things that can happen when you die. Either the living annuity proceeds will be paid to whoever you nominated, and if you didn't nominate someone, it gets paid to your deceased estate. That's it. No discretion. That's it. Those are the two options. Now, with regards to, so before I answer you on the third line, so let's now talk what happens when the annuitant now passes away. Let's say I was nominated. I then have the option, that I'll be given the option to exercise. Do I want to take that proceeds in cash it out? Do I want to transfer it to an annuity in my own name, or do I want to do a combination, take a bit of cash and then transfer the balance? Obviously, the minute I transfer into an annuity in my own name, I'll have the same rights and restrictions and obligations that the original annuitant had. I'll then have a right to nominate whoever should get it in the event of my death. I'll get a right to be able to select my drawdown income, etc., etc. So you can't rule from the grave. You can't decide, you know what, I'm going to leave this to my daughter, but I don't like her husband. So when she dies, it must go to my sister. The minute that daughter accepts the nomination and decides to take the money and put it in an annuity in her own name, she will get the right, same as you did, to appoint a nominee. And that can be whoever that person wants. You can't rule from the grave. That's why you can't nominate a third line. So what happens if that person dies who I nominated? Let's say I nominated Pete to receive my living annuity at my death. Now Pete passes away in the meantime. That at my death then, that benefit is not going to be paid to Pete's deceased estate. Pete predeceased me. He never accepted that nomination. So in that sense, it's going to be treated as if though I didn't have a nominee on record, because at that point that I pass away, I don't. That person's predeceased me. So the money will then be paid to my deceased estate. If whoever I nominated died after me, but after accepting the nomination, then it will be paid over to that person's deceased estate. We've seen, especially with parents, I have seen, or spouses, if I can put it that way, I've seen where, for example, a spouse and a child was nominated, and the child then said to us, look, I don't want it, it's fine, let my mom have it. The insurer cannot. So let's say the mother was nominated for 50% and the child for 50%. So at death, they'll both then be informed that they've been nominated. They need to accept the nomination and then make a decision of what do they want to do. Those three options I mentioned. An insurer can't give effect to transferring something you were nominated for to anybody else. It doesn't have that discretion. There's no discretion. The definition of living annuity says how it works. You pay it to the nominee, and if there isn't one, you pay it to the deceased estate. So that portion that the child doesn't want will in fact then be treated like a renunciation, and that 50% will then go to the deceased estate. You can't instruct the insurer to give your benefit to anybody else.
Yeah, makes sense. What about minor children, Lize?
So typically, I mean, it's completely common to nominate a minor child. Obviously, the whole principles of how does it work, minors obviously have limited contractual capacity or none. Certain laws, like when you're 16, you can open a bank account, or if you're 14, you can sign as a witness in a will. So certain legislation gives little pieces of rights depending on age, but in its most basic form, obviously, if you're under 18, you don't have contractual capacity, so your guardian will act on your behalf. So again, if it's not, a child is nominated, the guardian will have to elect the options that are given to any nominee, and any income that's paid will then be paid to the guardian on behalf of the minor.
Okay. Thank you very much. We are basically out of time. So let me I'm sort of toying with the idea whether I should let me ask this estate planning question just very quickly as it relates to estate planning, right? Because the beneficiary part of this is really important, but also a lot of times people say, well, one of the big benefits of living annuities are that you bypass the estate, that you don't pay estate duty, etc. So, and that's obviously also the case if you purchase a life annuity. I mean, that money that you contribute, like in the retirement fund, it wasn't part of the estate because it belonged to the fund. Now it gets moved to a living annuity. It belongs to the insurer, that capital amount, and that is not the case. But in the case where one, I don't have a beneficiary, or two, I did intentionally say it should go to my estate, and the money pays to my estate, does that value then come in? Does it always come in? Does it depend? Any ideas around how that would work?
Okay, so I'm going to answer you I'm going to be such a lawyer now. I'm going to answer you from a purely legal answer. So in terms of the State Duty Act, obviously it tells you what are assets and then also what's supposed to be deemed assets, and then there are certain exclusions. So anything coming from membership of a fund or past membership of a fund will not attract a state duty. So even if it gets paid to the deceased estate or the beneficiary, there won't be a state duty on living annuity proceeds. If it does get paid to the deceased estate because you didn't nominate someone, it will be subject to executive fees, though. I would like to put a different spin on your question. It's not a means of avoiding estate duty. It's completely an opposite concept in the sense of, remember, the whole point is when you retire, you by law are compelled to buy a compulsory annuity, subject to certain exclusions. We're not going to go into that in general, right? Because the point is that the government wants to make sure that you don't end up being a burden on the state eventually. So, and for the very same reason, pension fund monies, as well as once you get retired, in terms of the SARS general binding ruling, that protection that you have against creditors and all of that in terms of 37A of the Pension Funds Act applies to your post retirement as well, to your annuities as well. You're not supposed to have the money go anywhere else. So it's not a way of avoiding estate duty tax. It's actually a concession by Treasury for how they've worded the legislation, that the intention of this is it's post-retirement money and it must be protected and must go to whom it's supposed to go to.
Okay. Lisa, thank you very much. I think I'm going to end there. It was an amazing conversation. Thank you very much. So there's so much more that we can unpack. And I think, also around like particular cases, sort of getting more into the practical side of things. But I think this has given us a lot of clarity around the things that we need to look out for when it comes to living annuities, the aspects that we should really emphasize for our clients when we educate them on what it is that they're buying, and making sure that they truly understand all of the implications. And I think particularly this whole divorce issue is also very important for us to understand. So thank you very much for everything that you've shared. And it was a fantastic conversation from my end. So I don't know, any last words you want to leave people with, or if you want people to connect with you on LinkedIn, et cetera, but what would be your sign off for us today?
I think my sign off would probably be make sure that you go have a read. Google my name. In that case, you'll find articles where I broke it down nice and simply. If anybody wants the actual Untanari judgment, drop me a LinkedIn chat. I'll send you the case. It's incredibly important for clients to understand that, because I really believe that it's been completely misunderstood and miscommunicated post that judgment. And I think it has a massive impact, because people might think, okay, now we can, finally we can make sure we get part of that money as well, and then have a completely different approach to how they've approached their divorce. And they'll be very unpleasantly surprised once the order is granted. Nobody wants to end up with an order that costs you a fortune and it's not enforceable.
Brilliant. Lisa, thank you so much. Please go and connect with Lisa on LinkedIn at the very least. And thank you very much, Lisa. I look forward to working with you somewhere in the future and to have some more conversations. And just thank you for your time. Really appreciate it.
Anytime. Thanks for having me.
Thank you very much for joining us today. My guest next week is Richard. Which Richard is it? Mulholland. Richard Mulholland is my guest next week. And we're going to talk about Relentless Relevance. It's his latest book and a few other things as well. He wrote another book called Here Be Dragons, which is all about storytelling and story selling and all that good stuff. So I'm going to get into that with him. He's coming to us live from over the water. So I'm looking forward to having Richard on the show next week. And on that note, obviously next week, same time, same place. Until then, stay safe, be blessed and prosper. Stay curious and continue to raise the bar. Love you lots. Thanks for joining us. Bye-bye. Thanks for joining us on Propulsion. If you found value in today's episode, then there's plenty more where this came from. You can find all our previous episodes right here on the podcast as well as on our YouTube channel. And talking about the YouTube channel, we go live every single Friday at 8 a.m. until 9 a.m. and we host many different guests, and we also talk about very interesting topics. And on the live show, there's also some incredible segments hosted by some of the most well-known and influential financial planning professionals. So you are most welcome to join us every single Friday. Put it in your diary and we will see you there. And on that note, also please do check out propulsion.co.za/community for all of the goodness and learn more about how you can become part of our amazing community and how that would benefit you, your business and your career. So on that note, stay curious and keep raising the bar.